And our general counsel, Mr. Steve Price, is going to speak to everyone today and try to clarify a little bit where ACHD fits in with the whole development process. And so we thank him for his time and his efforts on this, and I will turn it over to
Okay, thank you. Welcome. Steve Price, for the record, Steve Price, ACHD General Counsel. Today I've been requested by the Commission to provide a workshop on where ACHD fits within the development review process for the cities and the county. But what I'd first like to do is Christy Little, she's our Development Services Manager. I'd like her to do initial presentation on the type of applications that we review, the type of comments that we provide on those different types of applications, and then I'll follow it up with more of a legal analysis of ACHD's powers and responsibilities within the development review process. So I'd like to introduce Christy Little. She is an amazing member of our team. She's won just about every award that you could win in the past year. She's WTS Woman of the Year. She's, well, it's a whole list, but anyway, I'm excited and looking forward to her presentation. I hope you are as well.
Excellent. Welcome, Christy. Thank you, Mr. Price.
Guess I should have had better remarks prepared for today. Thank you, commissioners. For the record, Christy Little. This will be very fast. If you have any questions, please stop me. And this is the easy part of the presentation. So we're just going to go over the Development Policy Manual, Section 7100, that outlines how we handle applications from the land use agencies, and then a specific area pertaining to preliminary and final plats. There are many more. Each agency has different types of applications, but at the end of the day, these are the general categories. So these are the types of applications that are transmitted to us: annexations, rezones, comprehensive plan amendments, conditional use, design review, certificate of zoning, minor land divisions and records of survey, master site plans, specific area plans, planned unit developments, and preliminary plats. Now, ACHD, with regards to development applications, handles different application types in different manners. So as a commenting agency, ACHD responds to annexations, rezones, and comprehensive plan amendments. Now, the information we provide is information about the impacted streets, how wide they are, if they have sidewalks, estimated trips, if the land use agency at this point in the development stage required a traffic impact study, we'll provide a summary of the traffic impact study. We'll outline what our relevant policies are that would pertain to this site, such as frontage improvements, stub streets and connectivity, street widths, access management. And then we'll outline potential requirements for future applications based on those policies. Depending on, again, the land use agency, sometimes these types of applications come with general site plans, and sometimes they don't come with anything more than just a narrative. And then these are the applications where ACHD is a recommending agency. So again, the comments provided to the land use agency will be very much the same as the prior category. Again, we'll be able to provide more detailed information at this stage because of the type of application. So trips will be more specific. If the application met thresholds for us requiring a traffic impact study, that information would be included. And then again, the relevant policies, frontage, connectivity, street widths, access management. And then instead of potential future conditions, we list out site-specific conditions of approval, which are enforced by the land use agencies per agreements that we have in place with them. And then ACHD, as the approving agency, is only applicable to preliminary plats. So State Code 401415 states that all subdivision plats required to be submitted for acceptance and approval to the city and the county shall be submitted to the highway district for consideration for acceptance and approval as to continuity of highway pattern, widths, drainage provisions, right-of-way construction standards, traffic flow, traffic volume demand created by the proposed subdivision. So again, the information provided in the ACHD staff reports for preliminary plats is just like all of the other applications, except that the site-specific conditions of approval are per statute. And then final plats, just as a reminder, I guess, here at ACHD, that's an administrative approval. So we don't sign a final plat unless all of the conditions set forth in the preliminary plat have been met. We don't add additional requirements or remove requirements. It's whatever requirements were set with the preliminary plat are required to be met before we sign the final plat. Okay. So that's my brief overview. Do you have any questions?
Thank you very much. Commissioners, does anyone have any questions for Christy?
Well, I have several questions.
Okay.
This might be a good time then, I'm sure, if Mr. Price wants to jump in.
Okay.
So, and we've seen this a number of times with developments that cities, that are happening in cities, particularly mixed-use developments. The city might want to have some more features. For example, narrower street widths to enhance pedestrian activity, enhance the private investment that already exists. We don't measure those enhancements, but the city might want to come in, and they can do that, can't they? They can come in and say, we'd actually like this to be a little narrower. We'd like to have bulb outs or wider bike lanes or something like that.
That's
So
correct. President May and Commissioner Hanson, when the land use agencies come to the highway district, first we work within our policy, but oftentimes those additional features that they're asking for, we try to incorporate them as much as possible.
Yeah.
You know, with regard to street widths, that was, you know, a concern of the commission a couple of years ago. And so we did work with the land use agencies as a whole to change the street width policy for the agencies that were interested in that. But certainly if they come to us during or before the application is being reviewed, we're happy to work with them.
Right, but so would the city need a policy? I mean, here's a developer coming in saying, you know, the only policies are ACHG's policy. They say we can have our streets this wide. The city needs a policy in order to do that?
Well, the city is also working within fire code, which is a major
Right.
major reason for street widths. Some of the cities also have, CUNA, for example, they require 8-foot wide sidewalks on arterials, which is wider than ACHD's. So if CUNA's standard exceeds what ACHD's is, then that's within their code and they can require that.
Okay, so that, and the same thing with you know, street, what is it called, frontage improvements. You know, they might require things related to the value of the property because they want to enhance the value of their tax base, whatever, as well as the walkability or so forth. And they can impose those requirements?
Madam President, Commissioner Hanson, that's correct. And downtown Boise is a great example of that with CCDC and their streetscape improvements and those requirements, which often involve wider sidewalks, different materials, bulb outs at intersections. And so we do work with those agencies.
So we have two sets of policies. One's the ACHD's basic policies, and then the city has a set of policies or could have a set of policies in order to say we would like these enhancements. So we basically have two sets of policies that apply with respect to the transportation infrastructure within any new development, right?
Madam President, Commissioner Hanson, that's true to some extent. It's not true with all agencies. Some agencies have broad policies about access management, but not specific dimensional standards.
And then presumably they'd have to have staff to review and evaluate those transportation aspects to the policies in this development, right?
That's correct.
Okay. Now, we've had extensive discussion about actually measuring, balancing out level of service of cars and other levels of service for people who want to use transit, who want to walk. And so that it actually is the livability side of the livable street design in order to get more livability value out of it. We don't measure that. And we went through a process saying, we're not going to measure that. We're going to stick with the level of service for cars. We don't do that. That's the cities. But so the cities would have to adopt level of service or level of stress or similar sort of balances for enhancing other modes of transportation, right?
Yes, they could.
They would have to go through that. I know it's in the highway users manual that these tools are there. We use that same manual. And so the city would have to use the same tools we do, could use the same tools we do, but they would have to adopt additional measurements, right?
Madam President, Commissioner Hanson, that's correct, and I believe some of them have.
Right. Yeah. Okay. Those are the questions. I think that the assumption is that we take care of it all, and in fact, there's actually two road agencies, ours and theirs, in order to figure out what the best transportation infrastructure and requirements would be on any development.
I've been waiting. Again, Steve Price, General Counsel for the record. I'd like to respond to a couple of questions. Madam President, Commissioner Hanson, as you know, within the law as a lawyer, that two jurisdictions can't have concurrent jurisdiction. At the end of the day, our authority to our plat approval is really, when we accept it and when the city or the county approve the plat, and we've signed the plat, then we've accepted that road meeting our standards for maintenance. If for some reason another agency does something inconsistent with our standards, and we don't agree with it, then we will not sign the plat and that road will not be available for maintenance. So far, well, I'll get into it, but I just wanted to qualify that I think that our staff and the city staff have worked well in coming to a consensus on trying to incorporate the design features that they want within their land uses. The cities and the county are land use agencies. We are a transportation agency. The statute's very clear as to who has jurisdiction over each of those responsibilities. So first I think that it helps to go through the Idaho Local Land Use Planning Act and show who has the responsibility for land use and who has responsibility for transportation. So ILUPA is found in Idaho Code 676501, and the purpose of the statute is to promote health, safety, and general welfare of the people. This is generally a concept that's found in the Constitution for municipalities in the county as general purpose governments. This is their sole responsibility, and they have a lot of power, police power, to ensure that. We don't. They also have the power to ensure adequate public facilities and services are provided as a result of a land use. And when we get an application from the city's also sent it to the fire department, the sewer, and other infrastructure providers to make sure that they can provide safe and adequate services associated with that development. We are just one of many agencies that review that application and provide comment on that, and to make sure that there are adequate public facilities. The other purpose is to encourage urban and urban type development with incorporated cities and to avoid undue concentration of population and overcrowding of land. So back in 2004, I just wanted to show that we went through the blueprint for good growth, and at the end of it, we developed a lot of different products to try and meet the needs of the cities in the way that they wanted their communities to grow. Finally got down to what's called an adequate public facilities ordinance. And This was to give them the authority to be able to have better control over where development goes to make sure that there was adequate public facilities. This was never adopted. You'll see that this draft was March 11, 2006. ACHD is not governed by LUPA, only the cities and county. In fact, this is a direct quote: "Every city and county shall exercise the powers conferred by this chapter." The planning and zoning, this is their, in developing the comprehensive plan, it's important to go through and see what types of issues that they regulate as part of the land use process. This is something that's often forgot, but they have to do an analysis of the provisions that may be necessary to ensure that the land use policies, restrictions, conditions, and fees do not violate private property rights, adversely impact property values, or create unnecessary technical limitations on the use of property, and a what's called a regulatory taking analysis. So if somebody thinks that the government's gone too far in imposing conditions on a development, they can request a regulatory taking analysis. These are the other types of issues that the land use agencies address as part of the comprehensive plan: population, school facilities. It requires an analysis of public school capacity and transportation considerations. I'll get into that in a minute. ITD and ACHD are part of that. Economic development, land use, natural resources, hazardous areas, public services, facilities and utilities, transportation. We'll get into that in a minute. That relates to us. Recreation, special areas or sites, housing, community design, ag, implementation, national interest, electric transmission corridors, and of course, public airport facilities. So the component that does relate to ACHD, this is what it provides: an analysis prepared in coordination with the local jurisdiction having authority over the public highways and streets, showing the general location and widths of a system of major traffic thoroughfares and other traffic ways and of streets, and the recommended treatment thereof. The component may also make recommendations on the building line setbacks, control access, and a proposed system of public or other transit lines. So they have that responsibility. We had a case related to the Ustick Road project, and this further defined what that all means, who has that responsibility ultimately. This is the name of the case, and this is a quote from Judge Neville. "It is the city's responsibility to prepare a comprehensive plan in coordination with the highway district, which has authority over such public rights-of-way, not that the city or highway district share the authority to plan and design public highways." So at the end of the day, we have sole jurisdiction, exclusive jurisdiction over that area. This relates to subdivision ordinances that the cities and the county, they have to provide. Their ordinances have to provide for the mitigation of the effects of subdivision development on the ability of political subdivisions of the state, including school districts, to deliver services without compromising quality of service and delivery. That is their function. That is not ours. Fees established for the purposes of mitigating the financial impacts of development must comply with the provisions of the Idaho Development Impact Fee Act. Denial of a subdivision permit or approval of a subdivision permit with conditions unacceptable to the landowner is subject to a regulatory taking analysis.
Mr. Price?
Yes.
Commissioner Goldthorpe has a question.
So aligning this with the adequate public facilities, if a jurisdiction, not ACHD, felt strongly that, say, development could not be serviced by their police or fire adequately, that could under LUPA be a basis for denial?
I believe so, or they're required to provide suggestions, if you will, or conditions on how the developer might be able to mitigate that deficiency.
Okay, thanks.
Thank you.
The one other thing that the cities are required to process the applications in a timely manner. I only bring this up because we do our best to try and get those applications and try and honor and coordinate with them to get those done as quick as we can. Any delays by any of the agencies that they see comments has an impact on their ability to meet this requirement. I did this one to test reading skills, but this is the provision that relates to public schools and the development of public schools. This is to ensure that a state highway system or local highway system can satisfactorily accommodate the proposed school project. The commission, which the Planning and Zoning Commission, shall request the assistance of ITD or are affected or the local highway jurisdiction if the affected roads are not state highways. This is when we'll get into the issues of, we'll report to them, we'll work with them on access, safety, pedestrian plan, crossing guard, barriers between the highways and school, location of school zone, need for flashing beacon, need for traffic control signal, anticipated future improvement, speed on the adjacent highways, traffic volumes on adjacent highways, effect upon highways level of service, need for an acceleration, deceleration lane. You can see there's a litany of items, and this is very important. This was a later amendment to LUPA. This is to make sure that the schools that are built, that they can be provided and meet the needs of the public taking their kids to school safely. And not just by car or bus, but it's also other modes of transportation.
Mr. Price, one more question.
Another question. When we were going through the process of evaluating the new high school that's been proposed out on Ustick and McDermott, was this the justification that we were able to fall back on, along with the private property rights, to make the decision that we did?
Madam President, Commissioner Goldthorpe, yes, our staff had worked with the land use agency and we've gone through that analysis.
Thank you.
So this is another provision. This is a requirement that if approval or denial of an application requires that it be based upon specific standards and criteria that are set forth in the zoning ordinance or regulation of the city or county. Such approval standards and criteria shall be set forth in express term in the land use ordinances. It means they can't approve things that aren't part of the law in order to permit the applicants, interested residents, and decision makers alike may know the express standards that must be met in order to obtain a requested permit approval. Whatever the nature of any decision, standard, or criterion allows, the decision shall identify aspects of compliance or non-compliance relevant approval standards and criteria in a written decision. So this is just to make sure that because of the private property rights, that everybody knows the rules of the game and what it takes to comply, as well as lets the city know what they can and can't do. They are the ones that have control over their own land use ordinances and regulations. We do not. This a little bit more. This really relates to the findings of fact and conclusions of law. The approval or denial of an application or authorized pursuant to this chapter shall be in writing and accompanied by a reasoned statement that explains the criteria and standards considered relevant, states the relevant contested facts relied upon, and explains the rationale for the decision based on the applicable provisions of the comprehensive plan, relevant ordinance, statutory provisions, pertinent constitutional principles, and factual information contained in the record. Okay, we got to, this is, well, we'll get into this in a minute, but this is important. This is further within the review process. Failure to identify the nature of compliance or non-compliance with express approval standards or failure to explain compliance or non-compliance with relevant decision criteria shall be grounds for invalidation of the approval or site-specific authorization or the denial of the same on appeal. And only the land use agencies through that process, an applicant or anybody who has standing can seek judicial review. And there's an Administrative Procedures Act that allows for that process. This is a statement again of the legislature. It's the intent of the legislature that decisions made pursuant to this chapter should be founded upon sound reason and practical application of recognized principles of law. Only those who challenge it to a decision demonstrate actual harm or violation fundamental rights, not merely possible thereof, shall be entitled to a remedy or reversal of a decision. That's more of a standing issue. And again, any decision is subject to a regulatory taking analysis. So that relates to LUPA and where we fit within it. We don't, we're a supporting agency like many of the other agencies. As Christy pointed out, this is the one statute where ACHD has authority, and it relates to really the physical design of the road within and surrounding a development. And she identified all those criteria. And our policies are focused on these issues. And again, here's kind of the initial part of 7200. It's outlining technical requirements, and we're a more technical agency than anything, and responsibilities for all developments, including not limited to requirements for street frontage improvements, right-of-way dedication, access, roadway design, stormwater, etc. These policies apply to new development projects and redevelopment projects and are intended to provide safe, efficient movement of people and goods and on the street system within Ada County. These policies are also intended to allow for reasonable and safe traffic flow and access for future users of the right-of-way. That's what we do. So, there was a Supreme Court decision that really identifies the responsibility between land use agencies and ACHD. This was a Supreme Court decision in 2003. And the decision holds that only land use agencies has the final authority to approve or reject the proposed development, including the final authority to implement conditions related to the transportation system. So that makes you kind of scratch your head and you go, well, what if they don't? Well, again, that goes back to what I said earlier, and that is, if we disagree, then that will not be within our jurisdiction for maintenance. So the other quote from this opinion is ACHD does not obtain jurisdiction over the streets until a developer deeded the street to the ACHD. Deeded could be means by a deed or by a signed plat. ACHD, as Christy had pointed out, we have internal agreements with land use agencies. ACHD will indemnify the land use agency if they impose ACHD's conditions of approval. Here's an example of a couple of those agreements. So in the development review process, there's over the state statute, over LUPA, there's constitutional issues relating to exactions. And an exaction is a condition for development that is imposed on a parcel of land that requires the developer to mitigate anticipated negative impacts of the development. Commissioner Goldthorpe, this is where we exercise that. We have to, a lot of our conditions of approval, you'll notice in the staff reports, it's one thing to deny a development, but it's quite another that we have a responsibility to try and find ways to mitigate the impact of that development on the road system. So we have that authority under the Constitution, but there are, of course, limitations on that. And again, this goes back to the mitigating effects of subdivisions. So exactions are, again, highway improvement necessitated to mitigate the impact of new development on the road system within and adjacent to the development, okay? And we call those on-site improvements. And impact fees are funds applied to mitigate the impacts of the new development on the arterial road systems and intersections caused by the new development. So when they pay impact fees, they are contributing to mitigate the impacts on the arterials that feed into that. And those are called off-site improvements. And there aren't very many, there are some jurisdictions that can only do exactions. Other highway districts in the state, we're the only one that can do impact fees. There are other jurisdictions in the United States where only impact fees can be used and they can't exact as much. But we're one of the few jurisdictions, because of the KMST, where we can do exactions and impact fees.
Just a question, because we're getting right into the meat of this now. One of the reasons for having this particular work session was because of the situation as evidenced by my lack of understanding about exactions. Back in December and January, certain things that we could not require or exact that had to do with plans that might be in our CIP or 5-year work plan or whatever. I need some more detail as to why that can't be done.
Madam President, Commissioner Goldthorpe, let's get through a few more and I'll try and answer.
I knew
it.
you were getting there. I just wanted.
But just initially, we can only, well, anyway, this is just the kind of the overall review process. That's kind of 100,000 foot. This is something that just kind of a flow chart. The city of Boise, on their website, they have flow charts for all the different types of applications. It's a fantastic resource for whatever type of application. And identifies who has responsibility for either being a commenting agency, an approving agency, or a recommending agency. So again, when we accept and approve a plat, ACHD is responsible for all highways within our jurisdiction, including public easement roadways within the subdivision. Owners of the land may dedicate public streets and rights-of-way to ACHD on the plat. We are the reviewing department on all plats within Ada County. We're the only one that has plat signing authority, and those dedications are not valid until we approve the road, accepts the dedication, and the lead agency, land use agency, approves the development. And again, development services, they're responsible for reviewing all the development applications. I gotta tell you, they are busy. It's amazing what they are able to do with all those technical requirements. Street improvement plans, construction final plats to ensure conformance to ACHD standards and conditions of approval. These are the two different sections. Planning review, of course, Christie has responsibility for, and development review is, of course, Bill Gall. And planning review, this is really to make sure that the developer makes meets the conditions of approval in conformance with our policy. We have inspectors that go out and do site inspections, and they make sure that that happens on all subdivision final plats. Now, Idaho's kind of confusing because we have a thing called a preliminary plat and a final plat. Preliminary plat really is just the plat. It's the one. That's the one that counts. And when we get a final plat, we can't amend it. It really is just an acknowledgement that all of those site-specific conditions of approval and standards of policies have been met. So this is more authority within the Highway District statute that says no dedication can be deemed a public highway or under the use or control of a highway district unless the dedication shall be accepted and confirmed. So we've actually had people just deed rights of way to us unilaterally, and then they call it a public rights of way, but that doesn't work. It has to meet our standards before we'll accept it into our system. And this is more language about the effect of us accepting the plat. We already went over that. Here's the stuff about the final plat and how that fits within the process. I'll move ahead a little bit. I want to get to some other stuff. And again, I've said this, that we'll accept it as a public road or plat dedication as long as it meets our standards and conditions of approval. So now let's get into the Commissioner Goldthorpe's juicy topic, and that is exactions and takings. Now this is, I gotta tell you, there's from here to Cuna, Mayor Steer, there's books on the law on exactions. And this is a U.S. Supreme Court. They've set the criteria for identifying when an exaction becomes a taking that requires compensation under the Fifth Amendment. Now, these are kind of if there was any lawyer in here, they would say, oh, but there's 100 other cases. Yeah, there are, but these are the two kind of essential cases that really guide us through the exaction process, and that is in Nolan versus California Coastal Commission. The Supreme Court ruled that exaction is legitimate if it shares an essential nexus with the reasons that would allow rejection of the permit, concept of mitigation of the impact of development on the existing system. So that case talks about, well, you just can't ask for money. You can't just impose conditions unless you can show that there's an essential nexus. That was the first kind of standard. And then it got a little bit tougher, and this is in the rough proportionality test in Dolan versus City of Teagard versus the Supreme Court held that the exaction is legitimate only if the public benefit from the exaction is roughly proportionate to the burden imposed on the public by allowing the allowed land use. This means the exaction is not excessive to compensate for the proposed development it would impose. So is there a silver bullet, Commissioner Goldthorpe, on this? No. But you've got really good staff. We go through and we make sure and we try and impose as much as we possibly can. Sometimes we get away with more just because the developer is really agreeable. If there was a regulatory taking analysis, this is what would have to be done, is to look at whether there's an essential nexus and whether the requested conditions are roughly proportionate to the effects of the new development. And the rough proportionality test must be determined on an individual basis, and the public entity has the burden to show the evidence. So that is when I think I told you, well, those are great conditions that you want, but we have to have findings of fact and conclusions of law to show our reasoning as to why we can do that. We have the burden to show that there's sufficient evidence in the record that would be able to justify that occurring. Now, so we talked about exactions. Now, ACHD is one of the few highway districts that has the authority, well, the only highway district in the state has the authority to impose an Idaho Development Impact Fee Act. These are the purposes of the act is to find an equitable program for planning and financing public facilities to ensure new growth and development is necessary in order to promote and accommodate orderly growth and development. To ensure, here we go again, hang on, adequate public facilities are available to serve new growth. And ensure that those who benefit from new growth and development are required to pay no more than their proportionate share of the cost of public facilities needed to serve that growth. So we've gone through, and Gary Inselman has been the head of the program. Our impact fee ordinance started, I believe, in 1991, right after this act. I think the act was implemented for ACHD. We've been through several reiterations of the ordinances. It's been challenged in court. It's had a legislative change, and there is a very complicated, trust me, complicated process into making sure that the impact fees that we charge meet that standard of proportionate share of cost of the public facilities needed to serve new growth. Everybody has a different opinion about whether it's sufficient. I'm not going to testify to that today, but between exactions and impact fees, we do a pretty good job. Here's the regulatory taking analysis requirement. The purpose of the chapter is to establish an orderly, consistent review process that better enables state agencies and local governments to evaluate whether proposed regulatory administrative actions may result in a taking of private property without due process of law. So that gets back to the Nolan and Dolan type of analysis, whether we could meet that constitutional standard. And we're a taxing district, city and county. And again, it would be in the violation of either state or federal constitution. Now, the one thing that we worry about is that if we get too aggressive in imposing conditions and it turns out to be a tanking, then there's this statute that requires us to pay the applicant or the plaintiff, reimburse them for their attorney's fees and costs. We don't like that one. Now, also, the commission is subject to what's called it's a federal act, the Civil Rights Act of 1871. It's 42 U.S.C. 1983 violations. Many of you have heard it as a 1983 action. Every person who, under color of any statute, ordinance, regulation, custom, or usage of any state, subjects or causes to be subject any citizen of the United States or other person within the jurisdiction thereof to the deprivation of any rights, privileges, or immunity secured by the constitutional law shall be liable to the party injured in an action of law, suit in equity, or other proper proceedings for redress. So this has been expanded to apply to local governments. A plaintiff can only prevail if they can demonstrate that he or she was deprived of rights secured by the U.S. Constitution or federal rights. Now, you know one thing, a private property right is within the Fifth Amendment. So here, municipalities and local governments are persons subject to suit for damages and prospective relief. Individual employees of local governments may be sued in their individual capacities for damages, declaratory, injunctive relief. So now it isn't just the highway district, it's your videotapes and your favorite TV. Section 1983 does not impose a state of mind requirement independent of the underlying basis for liability, but there must be a causal connection between the defendant's actions, the government's actions, and the harm that results, or the employee's actions. And the harm be a result of an action on the part of the governmental entity that implemented or executed a policy statement, ordinance, regulation, or decision officially adopted and promulgated by that body's officers or the result of that entity's custom. Now, there's certain types of regulations that on their face, they are a taking, and then there's some that are as applied. There's a different analysis. The U.S. Supreme Court's told us what those are. And so we're mindful of that in the development review process. But we believe we don't have any policies or ordinances that on their face result in a taking. So all the plaintiff has to do is state a claim for a deprivation of due process. The plaintiff must show that he possessed a constitutionally protected property interest and that he was deprived of that interest without due process of law. So that's really where ACHD fits within the development review process. I got to come up with some other issues that are confusing to the public as well as some other agencies about ACHD, and if I've got time, it'll only take me about 5-10 minutes.
Yeah, please do.
Yeah, are you going to talk a little bit about those conditions that we could not ask for, that the reason we cannot ask for them is hinged on their inclusion in our CIP?
Madam President, Commissioner Goldthorpe, I don't specifically remember the 8 of those conditions, but many of those related to offsite exactions. They related to thresholds that could not be supported by
They
evidence.
weren't part of what I was just asking. The part that I was asking was not being able to ask for any improvements to be accelerated on, say, Cloverdale Road for something like that. Because in our staff report, it said that under our policies, we cannot ask for those if they're already included in our CIP or 5-year work plan.
That is true. The reason is that is a mitigation requirement that is scheduled in the Development Impact Fee Act. And we can't go outside that. Now, if it's not in the CIP, we can.
And if we did, what would be the result? Would it be a taking then, or unlawful taking, or?
I believe that it would, yes.
Okay.
So one thing that's confusing for a lot of people, and that's quasi-judicial proceedings versus legislative. Mayor Steer, I know you know this one. And legislative, that's when the commission is sitting and considering ordinances, resolutions, or other policy that's legislative. It's policies. It relates to everybody within the county. It doesn't relate to a specific piece of property. A quasi-judicial proceeding is defined where the commission's required to make a finding based upon the evidentiary record, and that the commission sits as a judge and jury, and we're required to make findings based upon the evidence in the record, apply to specific facts to that particular circumstance. And this relates to whenever we're reviewing development applications, because it relates to parcels of land, access variances, and staff decisions. It's, as the commission knows, there's times when it gets confusing, but I think we've done a good job to keep those two separated.
So the end of my question is, does having a CIP impede the ability of the commission to do any exactions that might otherwise seem reasonable?
Well, as long as those exactions, now remember, there are two ways that we can mitigate the impact of a development on the system, and that is impact fees. So if impact fees aren't eligible, then exactions is our tool. But then we have to meet those standards.
Okay.
So here's a little bit more on the open meeting law and the quasi-judicial. You can't have ex parte communications in a quasi-judicial action because of the requirement of having a record, and all the commissioners are the ones that need to hear everything when making the decision. So if one commissioner has other facts than the other commissioner, then that's what the ex parte communications relates to quasi-judicial action, not necessarily with the legislative. And our commissioners are good about identifying those ex parte communications, but that's why they have to do that. And here's a little bit more on that. So another one is, a lot of people, they're confused about, well, what is so any highway in your jurisdiction you're responsible for? No. We're only responsible maintenance obligations for open rights of way. And that's when we accept a road that meets our standards. So if somebody has an unopened right of way, they come to us and they say, well, will you open it? And we say, well, yeah, if you bring it up to our standards. So here's the statute, it's 40-202, and the pertinent language is provided, however, a county with highway jurisdiction or highway district may hold title to an interest in real property for public rights-of-way purposes without incurring an obligation to construct or maintain a highway within the right-of-way until the county or highway district determines that the travel necessitates, that it necessitates public travel, justifying an opening within the rights-of-way. The lack of opening shall not constitute an abandonment, and mere use by the public shall not constitute an opening of the public rights-of-way. This is in another subsection that says that we have no duty to maintain that unopened rights-of-way, and we'll have no liability if anybody gets injured from our failure to maintain it. And again, here it is again. We'll have no duty to maintain that public right-of-way, nor shall there be any liability or injury resulting from the failure to maintain it or any highway signs. Now, ACHD commissioners, you only have responsibility to keep the highways. This is your central function, and that is to keep the highways in their system in proper repair within the limits of our funds available to the highway district. This is where those people think that we have a printing machine in the back and we print money. The commission deals with the limitations of funding and having to make priority choices of how to spend that money. And it's been a struggle in the last few years. So I want to talk about the revenue a little bit. This is from our proposed budget this year. This is where we get our money, the bulk of it, property taxes. And you can see that the highway districts in Idaho were funded predominantly by property taxes. We do get some money from the Highway Users Fund, which is gas tax, state registration fees. We get some impact fees, and of course we get some federal aid. And this is just a graphic of all of the different, we have different registration fees, we have sales tax, revenue, and impact fees. And here's, if anybody really wants to strain their reading and really get into the details, that's the exact numbers. So within that funding, all of this funding, because ACHD is a special purpose government, we just can't spend that money any way we want. We have limitations as a special purpose government. We have a limitation on that fund. We just can't go spend impact fees in a discretionary way. The funding for the gas taxes, the highway distribution account, registration fees, and property taxes, those are limited for the construction, repair, maintenance, and traffic supervision of the public rights-of-way. So that's it. And sometimes we'd like to spend it on other things, but we can't. And it is the Constitution and the statutes, it's a limitation of power rather than a grant. This is the difference between a general purpose government and a special purpose government. The general purpose doesn't have that limitation. Special purpose governments do. So the rule of law in Idaho is where special funds or revenues are dedicated to a particular purpose, the same cannot be used for any other purpose, and any attempt to do so is unconstitutional. And here's more language. It's all over. It isn't just there. It's in the Constitution. It's in all of the enabling funding statutes for highway districts. Here's the registration fee, construction, repair, maintenance, and traffic supervision. They say it a lot because they don't want anybody to forget it. So in addition, that's an issue that a lot of people are confused about. Now, in terms of impact fees, we have to keep those separate and apart. Those fees, they have to be used in a very specific way. And so we segregate those, and those only relate to those system improvements that have been identified within a capital improvement plan.
Mr. Price, I have an impact fee question specifically that relates to any authority or opportunity for the land use planning agency to ask us to spend impact fees from a particular development on off-site improvements that development might require.
Well, Madam President, Commissioner Goldthorpe, we can only spend those impact fees for projects identified within the capital improvement plan.
Right.
So if they want to accelerate a project that's identified and use impact fees to do that, they can request that.
Okay.
Yeah.
Thank you.
And they typically do in our prioritization.
Okay.
So one thing we can't do is we can't, because of the constitutional limitation that they have to mitigate the impact of new development on the system, we cannot use the expenditure of impact fees to pay for existing deficiencies. That's both in state law as well as in our ordinance.
About future deficiencies caused by a development.
That's the CIP, yeah.
Okay.
That's
So
what it is.
That's different than what you just said.
Well, okay, maybe I misunderstood.
If there is a deficiency on a particular street, let's say Cloverdale, and you got 20,000, 25,000 more vehicles coming pretty quickly, can we utilize those impact fees earlier than maybe we had programmed them for, or programmed other revenue for, if the city council or the planning and zoning people ask us to?
Yeah, yes, you can, but as long as that is within the CIP.
Yes.
Okay, so the existing deficiencies would be the two center lanes. The two outer lanes would be necessitated by new growth, and that's the reason why it would be in the CIP. And those impact fee funds could be used for that. And the
Yes.
cities most certainly have the ability to request us to change the priority to accelerate that project.
Okay,
Did I get it?
yes.
Okay.
no.
I think you nailed it there.
So that's it. I hope that that's helpful. If you have any questions, I'll stand for those.
Very good. Any other questions,
Yep,
Mr. Price?
just,
Commissioner Hanson?
unless you have some, Commissioner Arnold?
Go ahead.
So under KMST, it's the ultimate authority of the cities, the general purpose governments,
And county.
cities and counties, yeah, general cities and counties. I'll use the term city as including county.
Okay.
As the general purpose. But they can't just willy-nilly impose conditions. They have to have some sort of specific standards adopted in their ordinances and policies, right?
Correct.
Now, those policies will affect transportation, but they could be based on that long list that you showed. General welfare, health and safety, housing, economic development, all those various things. There's a link between what their ordinances and policies do with respect to the transportation infrastructure. So they could then say, okay, we would like something different in this area for the taxpayers